Okay, the time is now 6:05 p.m. and we are back in open session to consider the level 3 grievance appeal of Jeremy and Beth Walter, parents. Mr. and Mrs. Walter are appealing the level 2 grievance decision made by Dr. Hensley Cohn, superintendent of schools for the Vernia ISD. This grievance is being heard in open session by request of Mr. and Mrs. Walter. I want to caution Mr. and Mrs. Walter that should your presentation discuss Vernia ISD students other than your own, then the grievance will be taken into closed session pursuant to sections 551.082 and or 551.0821 of the Texas Government Code. I'm Sean Stride, the board president. For the record, the quorum of the board is present, and the board's attorney, Jameson Baker, is present to advise the board and the board president with respect to this matter. Each member of this board must decide whether he or she is able to serve as an impartial member for this grievance and arrive at a decision based solely upon information and documentation presented at this grievance presentation. Any member not able to act in such a manner may say so and ask to be excused. I now ask each member to state their name and affirm that they can act impartially in hearing the grievance. I'm going to start with my left. Stu, can you act fair and impartial?
Yes, sir.
Brian Davey, can you act fair and impartial?
Yes, sir.
You heard me. Can you act fair and impartial on this matter?
Yes, sir.
Jeff Counts, can you act fair and impartial on this matter?
Yes, sir.
Jimmy McFadden, can you act fair and impartial?
Yes, sir.
Aaron Perdola, can you act fair and impartial?
Yes, sir.
I'm Sean Stride, and I will also act fair and impartial in this matter. In order to provide the most accurate record of this proceedings, a recording is being made. Please avoid talking when others are speaking so that the recording will reflect the proceedings accurately. The recording of what is presented here tonight, the board packet that was shared with the parent prior to the board meeting, including the district's policy FNG legal and FNG local, the agenda and the minutes of this meeting, once approved, will constitute the official record of this grievance. For the record, Mr. and Mrs. Walter are present for this level 3 grievance proceeding. Mr. and Mrs. Walter, will you and your representative please identify yourselves for the record?
Jeremy Walter.
Bethany Walker.
Rhonda Davis. Brian Walter.
Will the members of the administration present please identify themselves for the record, starting with our attorney?
I'm Hannah Kramer. I'm an attorney with Walsh Davis, Kyle Robinson, and De Los Santos, and I'm here with the superintendent, Dr. Cohn.
Mr. Thomas, Superintendent.
You want to pass it to the next row? But we'll go right behind you. Yes.
Brian Knoll, Athletic Director.
Randy Anselka, Principal. Sarah Elliott, Assistant Principal.
Thank you. These are the procedures for this hearing. First, the parents or their representative will make their presentation. When finished, the administration or their representative will be permitted to make a reply. The parents and the administration are each allowed 15 minutes to make their respective presentations. After the conclusion of both parties' presentation, I will allow each party 3 minutes to give a rebuttal statement. Either side will question or cross-examine the other side. Within the specified timelines, the parents will make their presentation of what they want the board to consider. The administration then will give an opportunity to respond. After the parents and the administration have completed their presentations, board members may ask clarification questions of the parties. Board members, I request that you refrain from interrupting or asking your question until both sides have finished their presentations so that we can maintain an accurate record of the time used by each party. Are there any questions from anybody regarding the content of this hearing? Okay, now we're going to proceed with the parents' presentation of the grievance. Once you're ready, I want to start the timer at 15 minutes.
Thank you, President Stride, Board. My name is Vernia Davis. Again, I'm assistant to family. I could understandably a little nervous to be in front of me today and a little disappointed to have to be here. We're going to have Brian speak and Brian's mother going to show a brief video. I do want to kind of put it really succinctly at the beginning. seems more reasonable and plausible that a beloved student attacked another student on the field, deserving of a harsh disciplinary judgment, or he was kicked and tried to self-defend himself, break away from it, and it looked bad on video. They got posted on social media.
Why are you dancing that way?
Keeps cutting on the field. I really think that's the easiest way to put it. What's more realistic? I'm going to go ahead and scoot one over. I'll let yeah.
There's a red button right over there. It's on the back.
Small. Press it. Yes.
Good afternoon, everyone. I'd like to say thank you to everyone who came to support me today, and thank you to the board for letting me speak this afternoon. I want to be clear about my intent in this situation. I did not have intent to hurt anyone. I felt confined in those moments, and I was trying to get away and not escalate the situation or cause harm. That is the truth. I walked away. I would also like to say I have always taken pride in representing my school in anything from teams to my community the right way. My coaches, teachers, and friends know I am. I work hard, I respect authority, and I try to lead by example. And in moments when I'm wrong, I take responsibility. The punishment I have received has taken opportunities that I cannot get back. I missed homecoming, multiple school events with my friends, valuable classroom instruction, and I have felt the weight of a label that does not reflect who I am or how I conduct myself. What has been the hardest part of all of this is knowing that people who know me and wanted to support me felt they couldn't speak up, and that has been difficult to accept because this community has always meant a lot to me. So with that, today I'm asking for fairness, not special treatment. I'm asking that my actions that day be judged based on full facts from my intent, my record, not based off assumptions or narratives that don't reflect what actually happened that day. I would also like to say thank you to my coaches, teachers, and the staff that came to visit me today. Thank you. Thank you.
Good evening, board members, administrators, and our community. My name is Vernia Walter. I'm here tonight not just as a mother, but as a voice for fairness, truth, and every student who deserves to be treated with dignity, not politics. Tonight, you see a packed room because people are paying attention, and what you decide in this room will echo far beyond these walls. We're here because of a moment on October 23rd, but more importantly, we're here because of everything that happened after. The process, the punishment, the silence. I have reviewed this video frame by frame, over and over. We've laid out the facts. Those facts show something that most of us now know. Bryden did nothing wrong. He didn't start a fight. He didn't throw a punch. He didn't retaliate when he had ample opportunity to do so. He got up and walked away. He followed the very standard of sportsmanship we ask of every student athlete in this district. And yet, it was Bryden, with no disciplinary record, no history of foul play, a solid academic record. It was Bryden who was pulled from his peers, removed from his team, and now told he can't even try out for the sport he loves the most. This isn't about accountability. This is about convenience, about optics, and about protecting the adults in the room, not the student who did the right thing. And if we can't call that out, if we can't correct it, then what exactly are we teaching our kids? If a student who follows the rules can still be cast aside to protect the system or save the district from unwanted attention, then we have a much bigger problem than one football game. Let me make this clear. My son will not be a scapegoat. He will not carry the weight of adult discomfort or internal politics. He will not be punished because others fail to act with integrity. And I will not stand quietly while his future is sidelined to protect reputations that should be held to a higher standard. We have an opportunity tonight, not just to reverse an unjust decision, but to show every student watching that doing the right thing still matters. That walking away instead of fighting back is still the right choice. That when facts are clear, you will have the courage to act, not based on public pressure, not based on a dark history, but based on what is fair and what is right. Let tonight be the moment that this district proudly shows its integrity, not with words, but with actions. Pride deserves better, and quite frankly, so do all of our kids. Before I close, I need to speak to the process because how we got here is just as important as where we are now. The incident report used to justify this punishment is not aligned with what is clearly visible in the video footage. The positioning of witnesses, the sequence of events, and the narrative described simply did not match the facts. The footage tells the truth, and that truth was overlooked. Despite submitting detailed evidence, including witness accounts, frame-by-frame video analysis, and timelines, our concerns were never meaningfully addressed. At every level of grievance, it felt like our voices were just checked off the list. There was no follow-up questions, no clarifying discussions, just silence. Even more troubling, we have documentation showing the district executive committee issued a no further action email before our level 1 hearing even took place. That's not due process, that's a predetermined outcome. We were asked to trust the system, to work within it, to follow the steps, and we did, all of them. But the truth is, the outcome was decided before we ever walked into the room. If the facts don't matter, if the video doesn't matter, then what message are we sending to our kids about honesty, accountability, and fairness? We could play the video. It goes in slow motion. Yeah, it's just supposed to play all the way through. Now we're going to go with the slow motion. This is the huddle video side.
comments, please.
Hold them both face now.
Yeah, you got about 3.5 minutes.
Yeah, so just to clarify, as you all just watched, the video looks different at different speeds, right? I mean, it's football, we're all familiar with the idea of instant replay. You know, one clip for maybe 10 seconds got posted on social media, and it looks very different. If you look at the huddle video, I think you can clearly see that the other students grab Brian's face mask and kicks him at least 2 times from the ground. He's holding down, he's kicking up. You know, to establish intent and say that Ryan was specifically trying to attack the other student, I think is difficult at best. Beyond that, regardless of that, what the families asked for at the level 1 and level 2 was a review of the facts and to look whether the punishment fit what happened. I think in the worst case scenario, we can say that this was a fight on a football field. Again, in the worst case scenario. And to go beyond that and say that it's something that deserves 45 days with the AP when other athletes get into fights on the field, you know, fairly often. Was this that extreme? Beyond the fact that our position is not even that there was an attack. This was a student trying to get away from another student, and it was very complicated on its own. I'm not aware that there was ever any review of what happened to the family's requests. Did he really attack another student on the field? And if it was this the right punishment for it? So I think, you know, sometimes people get it wrong. Families' position at the very minimum at this point, because so much time has passed, it's just that the administration got it wrong in doling out punishment here, and they're asking, can the board do something to fix it because of how it has affected Brian's ability to play other sports this semester and how it's affected his reputation. So, you know, again, at this point, we're asking for the board's help to try and make this better. Thank you.
Thank you. Concluded? Okay. Thank you so much. Okay, now the administration will proceed with their response. When you're ready.
Thank you, sir. In order to provide the full information to the board, my presentation does include student information, and so I just wanted to confirm that you all do want to proceed in open session. Okay. All right, good evening. My name is Hannah Kramer. I'm presenting on behalf of the administration this evening. I'm here with Dr. Cohen, the superintendent. We also have the athletic director, the principal, and the assistant principal behind me. I'm going to give you guys a brief timeline just of what has occurred, and then we're available to ask any questions or answer any questions after the presentation. Like you've heard, on October 23rd, there was a physical altercation between Bryden and a Beeville ISD football player. Based on the administration's review of the video, Bryden was not acting in self-defense. It appeared to the administration that he was on top, and the issue that the administration also took was taking the helmet off the other student's face and throwing it at him where it hit him on his body. On October 24th, the district reported this to UIL. It was reported by Beeville ISD and the Vernia ISD. That report is on page 137 of your board packet. On October 30th, Mr. Vandergriff sent a notification of the disciplinary hearing for a fight or scuffle and said that they were recommending DAP placement, and then he was placed in ISS in the interim. On November 3rd, Ms. Kelly served as the hearing officer. Originally, the administration considered 60 days, but then they reviewed his disciplinary history. He doesn't have a disciplinary history. They reviewed the video. They reviewed the statements. And because they did not consider this as an assault, they ordered 45 days. They applied, and the district is not required to do this, but they applied a 4-day school week factor. So you guys go to school 4/5 of a week or 80%. And so that brings the actual number of days down to 36. So he was assigned 36 days at the DAEP. That same day, the council reached out to schedule the MVR. So for November 4th, 5th, and 6th, he was in ISS. And then on November 10th, there was the MVR that this was not a manifestation. And so then the placement was in place. On November 4th, Coach Knoll submitted the findings to UIL. That's on page 148 of your board packet. And he tells UIL how the district is handling this with a summary of findings and accountability. And so this is, what he says is, here's what happened. There was a fighter scuffle, engaging in inappropriate physical conduct directed towards another person, throwing objects that can cause bodily injury or property damage, and then engaging in any conduct that school officials might reasonably believe will substantially disrupt the school program or incite violence. And then he let UIL know, here's what we're going to do. The student was placed in ISS pending a DAEP hearing. The hearing occurred. The student is assigned for 45 days, and the student is unable to participate in any extracurricular activities while serving in the DAEP placement. Based on the actions taken by Vernia ISD, Bryden did not face any consequences for UIL outside of those that the district issued. If you look at page 81 in your board packet, and I know I'm sending you all around, but this is the DEC, the District Executive Committee of UIL. They responded, and what they say is that they approve of the actions taken by Vernia ISD. Had Vernia ISD not taken appropriate actions, he could have faced a penalty imposed by the DEC. 83 through 84 kind of talks through what UIL can do. UIL can do an individual suspension, and they can do a reprimand, and those things can include a probationary period up to 3 years, which is much longer than the 36 days. And the DEC, their jurisdiction is they're required to rule on reports of violations of the Constitution and or contest rules that occur in this district. And so that's what the DEC did. They were satisfied with what the Vernia ISD did. That brings us to the grievance. So if you look at tab 9, that's the level 1 grievance that was heard by the principal on November 13th. The family was requesting that his punishment be suspended and that he be returned to class and athletics, and that was denied. And so the parents filed the level 2 grievance, which was heard by Dr. Cohn on December 10th. That's on tab 4. Dr. Cohn issued that decision on December 17th. That's at tab 2 in your binder. And in that case, the parents were again asking that his suspension, DAP placement be reversed, and then an amendment of his disciplinary record. Before I discuss the requested remedies today, there's just a few things I wanted to talk through. So at Vernia ISD, to participate in athletics, you have to be passing your classes, and then you cannot participate in extracurriculars, not just athletics, any extracurriculars, if you're at the DAEP. It's my understanding that Bryden has 3 more days at the DAEP. So if he goes tomorrow, Wednesday, Thursday, then he can return to regular classes, and assuming he's passing his classes, he can participate in extracurriculars, including athletics. Nobody gets handed a position on any team, and baseball has already had their tryouts, and so it wouldn't be fair for the people who have already participated in the tryouts for him to try out for that team. But for any sports that are open, he can try out and participate. It's my understanding that there are still sports that are open, like maybe track is still open for him to participate in. The student code of conduct, the district has a student code of conduct, and you all have an extracurricular handbook. These two don't conflict. So the student code of conduct applies to all students, whether you're in extracurriculars or not. And then for students who aren't extracurriculars, there's this additional standard that the district expects, and that talks through things for extracurricular students. It's not just for kids in athletics; it's for any extracurricular activities. And they don't conflict with each other. And in a lot of cases, the extracurricular handbook will say, look to the student code of conduct if A happens with the student extracurriculars. The reason the district determined was that the fight/scuffle, inappropriate physical conduct directed towards another person, conduct that substantially disrupts the school program or incites violence, and that's why he was assigned to the DAEP and why he has not been able to participate in district circulars. But once he completes that consequence, he can participate. One other thing I heard was that just moving forward, of course, the administration has no intention to ruin anybody's life about this, and I want to point out that under Texas law, disciplinary action like DAEP does not appear on a student's academic transcript. So it's not shared with colleges, universities, or potential employers. Those records are maintained only at the district level and are used solely for internal educational purposes. They're not part of a student's permanent academic record. They're not forwarded as part of any post-secondary application process. And the administration understands that any disciplinary action can raise concerns about the student's future, and so I just want to emphasize that this DAE placement will not impact Bryden's ability to pursue higher education or employment opportunities. And the Texas Education Code ensures that students are not unfairly penalized in those areas due to disciplinary procedures that are appropriately handled by the school district. So tonight there's two things that the family is asking for. One is immediate release from the DAEP. It's the administration's position that the 45-day assignment, which was reduced to 36 days based on the 4-day week, is appropriate based on the violations of the student code of conduct, and UIL agrees with that as well. They're also asking for a revision to his disciplinary record. There is a formal process for amending the student records, and so it wouldn't necessarily be appropriate for the board to do that this way, but I did print off a couple, or Dr. Coe prints off a couple copies of that policy, and so once this wraps up, I'm going to provide this to them so they can follow that procedure for amending student records if that's what they'd like to do. For all the reasons that I just mentioned, the administration respectfully requests that the board deny the grievance and uphold the administration's decision at level 2. Thank you.
Okay, now each side will have 3 minutes for rebuttal time.
Thank you. A couple of things. Can you talk about Bryden removing the other students? At this point, we were well into the scuffle. He'd been face masked. Our position is if you go frame by frame on that, you'll see that the helmet actually bounces off the other student's leg as he's going up to kick Bryden again, after he's already kicked him 2 or 3 times. And further, the back and forth of the way he's swaying, when you look from the 2 angles, you can see how the other student's pulling him back and forth. So, you know, there's a little more to it, and it's not necessarily that Bryden swinging a helmet at anybody. It's just the momentum of how things are moving. And it doesn't hit the other student. You can see the other student jump right back up and run. It doesn't hit the other student in the head as moving to the leg. So I just want to put that part out. Aside from that, within the disciplinary code, 45 days, reducing because you guys have a reduced week, it's the same effect. And what I want to point out is, very common kids go to DAE maybe 10 days, 15 days. This wasn't a fight on campus. This wasn't inciting other students. He was in the middle of the football field during the football game while he's getting face masked. I think the context matters within that. So that's certainly something to be decided. The other element I want to bring up is how much the administration is talking about UIL. Is UIL the one that decides the punishment, or does Vernia decide the punishment and then they go to UIL? This conversation, really the way it's been framed, to me, you know, I call into question whether this punishment was really what the administration thought was appropriate for the incident, or would cause the least issues with UIL. Because, I mean, I think it's pretty self-evident. This isn't a student that has a history of assaulting other students or causing any trouble or anything like that. And it's pretty clear that he got face masked. I mean, at the very least, you can see a face mask and 1 or 2 kicks. So I really question whether this severity of punishment was related to the incident or related to making sure that UIL was okay with what the punishment was. Had Vernia gone with no punishment or lesser punishment, the family could take it up with UIL if UIL had a problem with it, and we would be in front of them showing them slow motion video and trying to say that the other student instigated this. But that's not the situation we're in. We're here in front of you saying the same thing.
And so I just, I call into question the order of operations on this punishment. As the family brought up earlier, there were some decisions that seemed like they got made really, really quickly rather than going through the whole case. And it was appropriate for what happened on the field.
Okay, now the administration may present the results statement.
Yes, sir, thank you. I mentioned UIL because that was a part of their presentation. The district made the decision based on the student code of conduct and the DAP processes that the district has. The district reported this to UIL like they were required to do on October 24th. UIL didn't get back to them until November 11th. In the meantime, the district continued with their usual process of discipline. So if you look on October 30th, the district sent the notification of disciplinary hearing, and on November 3rd, the assistant principal served as the hearing officer and assigned the discipline. We don't hear back from UIL until November 11th, and discipline has already been assigned at that point in accordance with the district's policies. The district did report to UIL because that was their position that they were required to do that, but the district did what they believed was appropriate based on the district's policies and was not influenced by what UIL may or may not do. Thank you.
Okay, now is the time for questions from the board. So do we have any questions from any members of the board before we start? Where do you want to speak at first? Any questions? My question with the statement that you had made, sir, regarding the UIL ruling, so to clarify the situation for me, the Vernia School District made a decision regarding the action that happened on the field. Now, did the UIL not make a ruling, or was the UIL content with the ruling made by the school? What's the story on that?
Right. My understanding is UIL was content with the ruling made by the school. The question I was making is the way it was presented. The administration talked about all the things UIL could have done, but UIL didn't do those things. Vernia is the one that picked 45 days of DAP and affected the student's ability to try out for other sports, that affected his access to education, all these other elements. What I was speaking to was had the administration chosen no punishment or less punishment, then it would have been the family's issue with UIL had UIL ruled on something else. So yes, Vernia gave out a punishment. UIL looked at it and said, we're happy with this. But there was no conversation about whether that punishment was appropriate in and of itself. And that's the issue I'm raising, because we're saying that it's not appropriate in and of itself.
Would the UIL, and I'm asking maybe both sides here, but would the UIL say that if that punishment wasn't appropriate, do they have that right to step in and come down with their own decision on that?
I mean, I believe that's what the administration's case was.
Well, I'm not aware. Do you are you aware that's what could have been the case? Or as opposed to the UIL didn't decide anything when they were involved in the situation?
Certainly I'm speculating here. Had Vernia said, we don't think this was actually an assault, and we don't think our student did anything wrong, then Beville could have taken it up with UIL and said, we think this is what happened, and then UIL would have weighed in.
And even the DEC, which I'm assuming is that the DEC is the district, which is the football teams, coaches all together, all the different teams in our district are involved in that decision.
It's the district executive committee, and except that the Vernia's representation there was not on the DEC for this. Because the person who the district that's affected can't have their person
Correct.
on there.
Right.
But
And
yes,
the other ones involved in that are Beville, what about Calhoun, Bay City, El Campo, Floresville?
yeah, that's right.
Those are the schools that are involved in
And
that.
just to answer your question, on page 84, it's a screenshot of UIL, so it's not me saying this, it's just the UIL thing, and it talks about the penalties that may be imposed by a DEC based on their review. And I just want to clarify that the district does not think this was an assault. So I know that word's being thrown around, but the administration has not assigned DAP based on this being an assault. We don't think that this was an assault. It was for those reasons I listed earlier. And they did consider whether this placement was appropriate at the DAP conference, at the level 1, at the level 2. Those are all different
So, yeah, so what exact physical actions was it that the district basing it on?
The violations of the student code of conduct that,
No, the actual physical, I mean, watching the video, what were the physical actions that the district's saying were in?
I think reviewing number one, when it came to me, the decision, it was because the moment that helmet came off, and it came down, we get the previous couple was sportsmanship, like, and you saw the flag go into the air. So it wasn't really just the initial ball, it was the bringing it up and then coming down after the gift. And that's what I verified with number two.
The helmet coming down. Anyone else with questions about it?
Yeah, Sean, I do have just a quick question, and I really thank you for being here. I know this is a difficult situation for everybody involved, so again, thank you for being here. The information that you provided, that does not go unnoticed whatsoever. I just as a follow-up question, and maybe a point of administration, I know as part of the packet, the referee who was on the field that night provided documentation. I believe that, and I can correct me if I'm wrong, but the referee had to provide a UIL incident report. Is that correct? Does everybody agree to that? And I just, if I could, again, as a point of administration, in this report, the referee details that with 40 seconds left in the first half, I'm quoting here from the report, I am going to omit names and what have you, but with 40 seconds left in the first half, I noticed the player, the Vernia blocker for Vernia and the opposing team rolling on the ground. And I'm ad-libbing here just a little bit because I'm trying to omit names, if you will. So the referee goes on to say, I kept my eye on them as I saw the Vernia player pull the helmet off the opposing player and begin to strike the B-bill player in the head area. I yelled to stop for fear of injury to the B-bill player. The Vernia coaches came on the field, restrained the Vernia player. Again, I'm reciting what's in the report. So I'm just seeking some clarification.
Yeah, I mean,
That whole report needs to be thrown out.
I think,
That's all crap.
from anecdotally, my understanding of the game was being called pretty consistently in Beagle's favor the entire time.
Okay.
And so I don't believe that this ref was particularly favorable to Vernia. And I do think that using that report for any, factual elements, I mean, it's clearly out of line from what's in the video. And it was one of the points that the family made as far as procedurally, are we agreeing on what's happening here?
Okay. And from the administration side, any follow-up?
what injury did you have?
So I'm on page 33, the UIL incident report.
I don't think that there was a single document that the administration relied on. I think you have the coach's statements, you have the UIL statements, you have talking to the students, you have the videos. I mean, there was a lot of things I think that play into it. I do think that, the administration in looking into it and considering it said this is not an assault, which is why when they originally discussed 60 days, they went down to 45 days. And I think that even when they assigned 45 days, they said, let's see if we can apply the forfeit rule. So I think that they considered all of those things and not one had more weight than the other. I mean, I think the video probably has the most weight because you can just look at the video and see what happened. I hear that there's a dispute between people even who have viewed the video on how the helmet came off, but that's what the district considered was, there was a scuffle on the field. It happens at football games, there was a flag, but the helmet incident and then there was thrown a big hit, and I think it hit the other student to maybe the chest or stomach, that's what led to the disciplinary process.
Okay. All right. You don't,
perspective out this window, they have a teacher perspective out that window, and then they have to put together what they reasonably believe happened, which is a lot different than a court evidence-based court of law. And so, would I say that every statement from every coach in here, and the official, and our student do this and marry together? No, they don't. But that assistant principal has to look and preponderance of evidence in this totality and reasonably understand what they know happened at that point. What is the majority of the evidence? Because people do have inconsistency in what they see and what they hear and what they remember when they're giving a statement to their UIL Rotary Association 6 hours later, or the coach that gave the statement the next day. It's about cross-referencing to come up with what you reasonably believe happened. There's a whole different level of evidentiary standard than you should be running up and up.
So you're saying evidence, the evidence here is based on preponderance of evidence, which is a civil case versus beyond reasonable.
That's
Right.
exactly,
For the hearings.
that's exactly right.
I would agree with that. I think Mr. Baker can advise on that. From my, I don't think anyone is saying here that beyond a reasonable doubt,
Right.
any of this thing, anything is it. You just don't leave it out.
Our video expert will take care of this.
Does this just stop? All right, you see they've locked up here. They're going back. No one's face masking anyone yet. Takes him down. Yeah, and so here, he's pulling on his face mask. Bride tries to break free. So on the, if we go back,
Why did the ref watch it for so long and not stop it?
that's a great question. Okay, so,
Please, no comments out in the audience, so we can hear as well. You do not need any comments.
sorry, I'm having technical difficulties. Okay, here, he's trying to break free. The kid's got his hand, the Beagle player has black mask, or black gloves on. His hands are on his mask. Bryden's grabbing his hand here to get it off of his mask. It's gonna go fast, but because this next series of events. Okay, so right there, if we go back a little bit, it looks like, and I saw this on social media, a lot of people thought he was headbutting the other player. That's not what's happening. If you watch this player's feet, he's coming up and kicking him, and it throws Bryden forward, and it looks like he's headbutting him. Let's just. And then throws it. So when he throws that helmet down, this kid is bringing his knees up again to kick. As that the helmet probably would have landed on the turf. If you look at the helmet, it bounces up over his head. So I looked up the physics of it, and a helmet will only bounce off of turf, or a knee flinging itself back up to kick, because it's a equal opposite force, right? It's not going to bounce off a person. It's not going to bounce off of football pads. Those are designed to absorb an impact. Turf reflects the impact. A knee coming up with opposite velocity is also going to return the force. he leaves. And then he gets up and wants to keep fighting.
We actually played this video, is there another video that you can go on?
There is so the huddle video, we didn't actually have, even though we had requested it several times, we didn't actually get this until the day before our level 1 grievance. So, I don't know, yeah. The LB view. Nope, that one, this one. Okay, so here, he's got him. And they go down. Right here, his hands are up on his mask. He is yanking him back and forth. He can't get free. And I will say, from this angle, we did have a couple of coaches' witness statements that were spot on. Can I mention the coach? Coach Herring, actually, he gave an exact, accurate description of what happened. And considering that he was on this side of the field, from where he was standing, it would absolutely look like that helmet hit the player. We were all sitting there and watched it. We thought the same thing until Brian came off that field that night, and we told him why the police wanted to talk to him, and he lost it. He was like, I didn't hit that kid. I didn't hit that kid. And if anybody knows Brian, he doesn't lie either. I had to dive in, and when I got home and we slowed it down and we looked at it, he didn't hit that kid. And that's why I'm fighting, because that kid from day one has stood up and said he didn't hit him, and nobody's defending him. But nobody cared that he was being yanked back and forth, so he's just supposed to have some kind of crazy cervical spine injury from having his helmet yanked all over the place and not allowed to defend himself. Even if he had hit him, it certainly would have been warranted under self-defense. But he didn't even do that.
Amen. Look, I've asked a couple of times to not be commenting. And if you're going to comment, then you can leave. There's no need for that to be going on right now while we're trying to listen to people. We don't need to hear your comments or your reactions. This is not the place for that.
One quick question. I know you gave us some documents here. Is this your document, or was this from somebody provided to you?
So
I was just curious.
No, out of curiosity, I had, we just threw it into AI because I was like, I don't know how many of these people will like actually see this, but it was Gemini 3 AI, and I uploaded both of the videos into it, and I said, please give me a forensic breakdown of these players, objective, and display whether penalties, personal fouls, any of that exists in this video, and that's what it gave me.
Any other questions from anyone, with members of the board? No? Okay.
Yeah, I might after our next executive session.
Oh, okay. For now, though, nothing.
For now.
Okay, all right. So the level 3 grievance conference is now concluded. I'll now review with members of the board the proper process for reaching a decision in this case. Having heard the level 3 grievance, the board has several options. One option, the board may vote to grant the level 3 grievance. Option 2, the board may vote to deny the level 3 grievance. Option 3, the board may vote to grant in part and or deny in part any or all of the level 3 grievance or requested remedies. Or option 4, the board may take no action. In making its decision, the board should consider only the grievance presentation and administrative response presented today at this meeting, as well as the documents contained in the record. We will not consider any statements, rumor, or other information that we may have heard outside of this meeting room. At this time, I'm going to ask the board members and Mr. Baker to step into closed session pursuant to section 551.071 of the Texas Government Code, so that the board may ask Mr. Baker any questions they may have about any legal issues involving the grievance. We will return to open session to deliberate on the grievance and to make our decision. The time is now 6:56 p.m.